And now, the Beacon of Justice Awards, which are granted to law firms for their work to promote equal justice. NLADA is delighted to recognize this year's winners for their pro bono work and other efforts to advance racial equity in 2020. These firms are vital partners in NLADA's effort to dismantle racial inequities and injustices. We look forward to our continued collaboration and congratulate the winners for their achievements and commitments to equal justice. 23 firms qualified this year, showing the depth of the private bar's commitment to tackling difficult issues related to racial equity. This evening, we are only able to present a small selection of their incredible work. In order to honor all the awardees, NLADA will proudly publish a digital book this summer outlining the path-breaking work of all 23 firms. So much impactful work making such a difference. Thank you to all.
Hi, I'm Steve Schulman, the pro bono partner at Aiken Gump. Last year, our firm devoted substantial resources in our pro bono practice to combating racial injustice. We were one of a handful of firms that started the Law Firm Anti-Racism Alliance. We also were involved in many issues related to racial justice protests. For example, we represented 2 clergy members from St. John's Episcopal Church in testifying before Congress. They testified about what they had witnessed in June 2020 when racial justice protesters outside the White House were brutally attacked by federal troops. You're going to hear now from 2 of my Aiken Gump colleagues, Amanda McGinn, an associate in our DC office, about our compassionate release and parole work, and from Roxanne Tisravesh, a senior counsel in our Houston office, about a case she's been leading with the NAACP Legal Defense Fund. Thank you.
Last year, Aiken attorneys dedicated a substantial amount of their time to criminal justice work, advocating on behalf of incarcerated individuals deserving of release on parole or under DC's recently enacted compassionate release statute if they were vulnerable to COVID-19 due to their age or underlying health conditions. We were proud to partner with a number of different organizations in these efforts, including the Washington Lawyers Committee, FAM, the National Association of Criminal Defense Lawyers, and the DC Public Defender Service, just to name a few. Because of these strong partnerships, we were not only able to help our clients secure their release, but we were also able to help them navigate the many barriers they face throughout the reentry process. For example, we helped our clients obtain their stimulus payments, ensured that they had safe and stable housing to return to. In the case of one of my clients, helped him obtain his election ballot so that he could vote for only the second time in his life. I know I speak for all Aiken attorneys when I say that we look forward to continuing our efforts in this area for the years to come.
The underlying facts of the action against Barbers Hill Independent School District involved 2 young African American teens who were faced with an impossible choice of wearing their culturally significant locks or being forced out of school. The Aiken Gump team involved in this litigation is proud to stand with the NAACP Legal Defense Fund in its fight against discrimination and against this discriminatory policy. It's also just been very meaningful to advocate on behalf of these 2 young men who simply want to wear their locks in their natural formation without being discriminated against. We achieved a pretty significant victory in this case a few months ago when the court granted our preliminary injunction motion, allowing the younger student to continue wearing his locks during the pendency of this litigation. And while we have a significant road ahead in the remainder of the dispute, we are very proud to stand with LDF in its fight to seek to overturn this discriminatory policy. Thank you.
The Holloway Project had its origins back in the summer of 2016. The firm asked me if there was something that I thought the firm could do concretely to combat the effects of racial disparities in our justice system. On the spot, knew we would create the Holloway Project.
these 924C sentences, these gun sentences, were never intended to be enhanced on a first offense. Todd Ellerby had 3 924C counts. So the First Step Act was passed in December of 2018. It also made some important changes to the 2 statutes that we focus on in Holloway, which are the Compassionate Release Statute and the 924C statute. When Judge Ammon reduced his sentence to time served, he had served just about 25, so he still had about 27 years left on that sentence to serve.
I always had hope that I was going to get out. When she told me that, she said immediate release, I fell down right there on my knees. Tears of joy. It was just unexplainable.
These gentlemen did not need to sit in prison for another 2-3 decades. Doing the Holloway Project, every victory feels incredible because you're so proximate to these individuals who are 3-dimensional human beings. Getting these people home to their families is enormously exciting and moving.
Deckard has always had a long-term commitment to racial justice, and it's one of the reasons I came to the firm. We've worked with the Lawyers Committee for Civil Rights Under Law, ACLU, and other organizations. But after George Floyd's murder, we've had lots of very difficult conversations, and then that transformed itself, quite frankly, to some of the work we do and some of the work that I've invested myself in doing, including on the voting rights matter. I litigated with the NAACP Pennsylvania State Conference. And that case came about as a result of the concerns we had after the primary election in June of 2020 that resulted from the pandemic hitting Black and brown neighborhoods much worse. There was substantial reduction in the number of polling places that were open in those neighborhoods. So we brought the lawsuit, and as a result of the lawsuit, we actually had the state, in the general election, there weren't the similar reductions in the number of polling places, so that people were able to feel comfortable to vote in person, to do so safely, and to ensure that their voices were heard. One of the most important things that firm has done, and I played a very small role in my case, is representing people who are incarcerated and therefore under the greatest threat, facing serious illness or dying as a result of COVID. So I worked with the ACLU, Abolition Law Center, and other partners to bring a lawsuit against the Allegheny County Jail as a result of conditions that really threaten people who have pre-existing conditions or who are old. And it resulted in an agreement that will allow us to do some monitoring, that there will be some testing, a vaccination plan. There's so many people, and many of them are Black and brown, who lack the ability to get a lawyer, who lack the ability to have the issues that they're concerned about being presented in court. And so that's one of the reasons I strongly believe that this is the work that everyone should be doing.
This really started through my partner Melissa Jampol's relationships with the National Association for Criminal Defense Lawyers. That organization and others began a clearinghouse for federal inmates who were particularly vulnerable to contracting a severe case of COVID-19. These were inmates who would not otherwise have had a voice.
So I went to the firm and I spoke to them about pulling together a group of attorneys to do compassionate release applications under the First Step Act. I had no idea that it was going to result in over 24 of my colleagues joining together, and we met bi-weekly. We joined up in pairs, and we put together applications that would address the plight of the prisoners, their health conditions, their family situations, and help them figure out reentry programs.
Melissa and I both are former prosecutors, so we were very familiar with the issues surrounding compassionate release applications. Along with handling our own cases, our role really was to empower the team to produce winning advocacy for our clients. We did this by tracking the progress of each and every case, advising on issues as they arose, and then frankly getting out of the way so that our talented lawyers and support staff could handle the matters.
And I'm so proud of our team because these took a lot of work, a lot of time, and we gave it all for our clients. And it resulted in the release of 5 separate individuals who were at risk of dying from COVID and freeing them from federal prison. And they all have done great since they were released. They've found great places to live. They found medical care. And it really is an example of the zealous advocacy that our firm is known for and that our team members displayed.
One aspect of our core values that resonates with me personally is the commitment to create opportunities for our attorneys and staff to step reasonably outside of their comfort zone and develop their practices through new experiences. Any number of mentors have given me those opportunities along the way, and it serves our clients well to pay it forward and help attorneys to develop their practices as well.
Pro bono has always been a priority at Kirkland. It's important work that makes a real difference in people's lives and in our communities.
A large law firm with the resources and talent of Kirkland & Ellis can step in and bring justice to a community.
We dedicate more than 100,000 hours to pro bono work for the vulnerable, the underserved, and the marginalized. Too often, these groups are also predominantly people of color.
I got involved in the Maryland HBCU litigation in 2009. I had attended an HBCU and was on the board of an HBCU. I think we put some 30,000 hours in the case. There were 2 long trials. There were 5 mediations, and each of the mediations was multiple weeks long. We had an appeal in the 4th Circuit. When all of that failed in terms of negotiating with the executive branch, I decided we would deal directly with the legislators. We reached a settlement of $577 million, which is one of the largest pro bono settlements in American history. This is going to make a huge difference in the lives of Black students.
2020 was an inflection point in many ways. We took on projects relating to equity in education, criminal justice reform, voting rights, civil rights, and immigration. During the pandemic, we helped small businesses who were struggling and facing hardship. We also worked with clients to set up nonprofits aimed at providing relief to those who were suffering. It's a privilege for us to be able to fight for people who otherwise would have no voice, and to help bend the arc of history towards a more equitable, inclusive, and just society.
We established the Racial Justice Initiative. This is part of our pro bono committee because we felt that we had to do something tangible as opposed to making some hollow statement that we were unhappy or affected by the occurrences in Minneapolis. So we decided to set up the Racial Justice Initiative, which is going to, with respect to cases and matters that we were going to act on in particular. Actually, I see continued growth with respect to the Racial Justice Initiative. As I've said often, pro bono is part of the DNA of the firm. And when the firm was founded over 60 years ago, the founding partners felt it was critical and important that we serve our community and provide legal help to those in need. So from my perspective, I see the pro bono committee expanding, getting more volunteers from the partners and associates and staff in making sure that through the Racial Justice Initiative, we do something important and tangible. One area that we focused on is in a litigation matter. We have co-counseled with the ACLU to bring a civil rights action against a prison in one of the southern states. Our goal there is to help release these prisoners who are suffering and being affected by COVID-19.
Hi, I'm Andy Klubach, partner at Latham & Watkins, and I am so honored here today to receive the 2021 Beacon of Justice Award on behalf of our law firm from the National Legal Aid and Defenders Association for the work we did on a voting rights case in the East Ramapo Central School District. That victory has secured and restored electoral voting power to a community that had been entirely shut out. It serves as a model for other districts to start to address issues of race, inequality, and funding in the schools. New York's East Ramapo Central School District has a 98% Black and Latinx student population. But for more than a decade, white voters, 98% of whom send their children to private schools, completely dominated and controlled elections, using a secret slating organization that did not allow meaningful participation by any minority voter. And as a result, they were able to siphon public school funds away from the public schools to private schools, which led to massive teacher layoffs, cuts to extracurriculars, cuts to kindergarten, and crumbling infrastructure in the public schools. So in 2017, Latham teamed up with the New York Civil Liberties Union on behalf of the NAACP and minority voters in the district, and we brought a lawsuit under the Voting Rights Act. In May of 2020, after a 5-week trial, we won a hard-fought victory that forever, hopefully, will change the electoral system in this school district. Then, on January 6th, 2021, just a few hours before we all watched on TV as protesters stormed the Capitol trying to overturn an election and deprive people of voting rights, that very morning, the Second Circuit ruled in our favor, affirming the trial court decision. And in the process, they affirmed the use of a new methodology that will be a model for other voting rights cases across the country. Now, quite frankly, this was the kind of case that everybody in our team dreamed about when we went to law school. And the opportunity that we got to work on it was just incredible. So as much as we'd like to thank you for recognizing our work with this award, we really owe thanks to our clients for letting us do the case in the first place and entrusting us to do that kind of important work. We know that organizations like the National Legal Aid and Defenders Association get to do this kind of fulfilling work each and every day, although it's probably without the same kind of recognition that you all deserve. So we are proud and honored that you asked us to join you and all of the other honorees here today to celebrate the important work that all of you do. Thank you so much.
Our own projects continue, like representing nearly 100 people serving harsh no-parole sentences for nonviolent offenses in Mississippi prisons. Our attorneys are seeking parole hearings for our clients in partnership with the Southern Poverty Law Center.
Since January, attorneys across MoFo, including here in Tokyo, have been helping the Southern Poverty Law Center with its 3 Strikes project. The goal of the project is to file a petition seeking parole eligibility for every individual serving a lengthy habitual sentence in Mississippi. If the petition is granted, the individual can seek parole from the parole board and have an opportunity to be reunited with his or her family and community. As a firm, we've written dozens of these petitions, and I look forward to writing many more.
Without training and real dialogue, how else are white people going to fully grasp how strongly systemic racism is baked into laws, policies, and attitudes?
Here at O'Melveny, from the minute you walk into the door, there's an expectation that you're going to find ways to give back.
You know, that quote, be the change that you want to see in the world. I feel like I'm a part of the change that I want to see in the world, at least from my slice of the legal community.
We are here to serve, to help one another, help our clients, help our communities, and to do so with kindness and respect towards one another.
Following the killing of George Floyd, Shepard Mullen partnered with the Georgetown University Law Center to create the Active Bystandership for Law Enforcement, or ABLE project.
ABLE teaches law enforcement officers how to intervene in another officer's conduct to prevent harm to the community and to the officers themselves. For decades in this country, we have demanded officers be active bystanders, but we haven't given them the tools to do so effectively until now. But ABLE is more than just training. ABLE drives cultural change by ensuring the principles of active bystandership are ingrained in a department's policies and its accountability systems. To date, more than 100 law enforcement agencies across the US and Canada have been accepted into ABLE. We already have trained more than 500 instructors in the principles and tactics of ABLE. These officers will then go back and provide ABLE training to more than 100,000 officers in their agencies, who then will go out and provide better, safer, and fairer policing to some 50 million people. Thanks to the generous financial support of Shepard Mullen, MasterCard, Verizon, PepsiCo, and our other partners, we continue to expand the program to reach more law enforcement agencies and thus more communities.
I have been so proud to lead Shepard Mullen's Police Records Litigation Project. Over the past 2 years, we have litigated up and down the state of California to help ensure that police records of serious uses of force and misconduct are open to the public for the first time in decades. The information is also critical to determining patterns of uses of force and misconduct and figuring out how to implement broader reforms in policing. Shepard Mullen's support for this project has been overwhelming. The firm has contributed well over 2,000 hours to litigating 9 cases and obtaining 3 published appellate court decisions, guaranteeing access to these records here in California. Our entire team has incredible pride in what we've been able to contribute.
What an honor for Shepard Mullen to win the Beacon of Justice Award. I'm so proud of the pro bono work that our attorneys took on this year in order to combat systemic racism and to improve policing.
Hi, I'm Allison Woodbury. I'm a partner in the Minneapolis office and co-chair of the firm's pro bono committee. Pro bono has been an integral part of my practice since I joined the firm in 2007. And why do I do pro bono, and why should you do pro bono? Because in doing so, we lift up the individuals in our community. And as we lift up those individuals, we lift up the community as a whole, and we lift up ourselves. It enriches us as human beings to serve others, to serve in a way that doesn't require or request remuneration, but simply to act to better others' lives. My pro bono work has been the most meaningful work that I have done at the firm. And it doesn't feel whole to me to be practicing as a lawyer without serving those who are most in need.
I think the question is, why do pro bono? I can give you one really good reason to do it. It feels good. Using your legal skills to help others is really, really rewarding and gives you an opportunity to contribute to the community that gives so much to you.
My name is Lucas Schneider, and I'm of counsel with Stinson's Denver office. I rise to the challenge to perform pro bono work because over the course of my career, friends, family, colleagues, professors, they've all supported me, and I too feel the need to give back. The COVID-19 pandemic has even increased the need for our prior pro bono clients. To that end, I've assisted a client with regard to force majeure clause enforcement to help that client save some costs over the course of this time while it rides out the pandemic. Thank you.
My name is Eleanor Wood, and I'm an associate in Stinson's Minneapolis office. I rise to the challenge to do pro bono work because I want to make a positive difference in the lives of individuals who would love to become U.S. citizens, but who don't want to have to navigate the naturalization process alone.
This is Andrew Scavato, litigation partner in Stinson's St. Louis office and member of our pro bono committee. I love doing pro bono work for so many reasons. My experience is that when I'm fulfilling my duty to do pro bono work, the rewards are profound, not just for the recipients, but for me and my colleagues. It's a satisfaction that goes beyond just fulfilling an obligation. For me, doing pro bono work is a great way to understand and appreciate the awesome power of our profession, and it makes me feel great about being a lawyer.
Hello, my name's Denise Zosa. I'm an attorney in Stinson's DC office. I rise to the challenge to do pro bono work for several reasons. First, it's the right thing to do. Second, I'm able to do good, actively engage, and make a tangible impact. Doing pro bono work also gives me a chance to give back to the community and help those who lack the same access. And lastly, I get to leave my box and learn a new area of the law.
My name is Christina Hansen, and I'm an associate in Stinson's Wichita office. I rise to the challenge to do pro bono because it's a powerful way to affect change in someone else's life. My pro bono work at Stinson has allowed me to partner with an organization that helps undocumented victims of human trafficking apply for T visas. These survivors have already endured unthinkable hardship and trauma, and now they're living in fear of deportation. I want to do my part to help them build a brighter future.
My name's Alok Sharma, and I'm a commercial litigator in Stinson's Minneapolis office. I have a very broad practice. These days, it's been a lot of sports. I currently serve as vice chair of the sports section for the American Bar Association. Sports are great because I'm passionate about sports, but I'm also passionate about pro bono legal services. For the last 27 years, the firm's had a medical and legal partnership with the Community University Healthcare Clinic in the Phillips neighborhood of Minneapolis. This relationship is called the Diner Legal Clinic. As officers of the court, it is incumbent on each and every one of us to ensure that those that do not have resources can still access competent counsel. Over the last 2 years, over 85 Stinson attorneys and paralegals have devoted their time and energy to the Diner Legal Clinic.
I'm Tom Sprankling in WilmerHale's Palo Alto office.
I'm Ryan Perio from WilmerHale's New York office.
At WilmerHale, we've taken on unjust bail systems across the country.
Along with the Southern Poverty Law Center and National Consumer Law Center, we brought a lawsuit on behalf of Ronald Igana against Blair's Bail Bonds, one of the largest bail bond companies in New Orleans. Blair's had a routine practice of sending armed bounty hunters to apprehend their clients, bring them back to Blair's office, and detain them there in handcuffs under the threat of surrender to jail until their family and friends could bring more money, even when the client was paid up in full. This happened to Mr. Igana on multiple occasions, including one time when he was taken from his workplace, causing him to lose his job, and another occasion where he was dragged from the steps of the courthouse, causing him to miss a court appearance. We brought federal racketeering and other claims, and after years of litigating, we were able to obtain a settlement that was both financially advantageous to Mr. Igana and ensures that no other New Orleans citizen would ever fall victim to these unlawful practices.
Particularly problematic are state cash bail laws, which often permit governments to jail people accused of a crime prior to trial, simply because they cannot pay the cash bail that a court demands in order to buy their freedom. Individuals from historically oppressed groups are disproportionately harmed by this inequity. That was true for Kenneth Humphrey, a San Francisco resident who was in his 60s, who was arrested on allegations that he robbed an elderly San Francisco neighbor of $7 and a bottle of cologne. The court initially set Mr. Humphrey's bail at $600,000, even though Mr. Humphrey told the court he could not pay. In front of the California Supreme Court, WilmerHale and co-counsel argued that under the Due Process Clause and the Equal Protection Clause, a court must take into account an arrestee's financial ability to pay and cannot imprison him solely because of indigency. In a unanimous decision that is expected to have a significant impact on every bail proceeding in the state, the California Supreme Court agreed, explaining that in our society, liberty is the norm and detention prior to trial is the carefully limited exception. The common practice of conditioning freedom solely on whether an arrestee can afford bail is unconstitutional.
Tom and I have told you about just two of the many important matters our firm is working on through its Racial Justice Reform Initiative. We are so grateful to NLADA for this recognition, and we're honored to be here with all of you who are engaged in the fight for racial justice.
Hi, everyone. Luke Liss, Senior Counsel and Pro Bono Counsel at Wilson Sonsini here. So first off, I just want to say hello. Hope everyone is doing well and enjoying the virtual gala. And we would just like to thank NLADA for awarding Wilson Sonsini with its Beacon of Justice Award, along with the other great award winners for its virtual gala this year. We're very honored to receive this award and view it as really a reflection of our work over the past year on racial justice. It's been a difficult year for everyone, but at the same time, it's been an inspiring year with all the efforts, not only for our firm, but so many firms have undertaken in terms of to make this world a better place, especially with respect to racial justice and civil rights. You know, for us, some of the things we've been doing is a pledge by the firm to perform $15 million in additional legal services for racial justice and civil rights on top of what we're already doing, which has been considerable. Establishing a Juneteenth Day of Service where our attorneys virtually this year, hopefully in person in following years, will engage with our communities to celebrate Juneteenth and serve our communities. And in addition to that, numerous litigation, corporate, you name it, projects to advance racial justice and civil rights. Some that come to mind include working with the ACLU of Louisiana in their Justice Lab project to attack discriminatory policing, taking on Innocence Project cases, working with numerous nonprofits that seek to advance minority-owned businesses and the causes of racial justice and civil rights overall. So lastly, I would just like to thank all of our amazing volunteers for the efforts and heart they put into this, as well as firm leadership led by Doug Clark and Katie Martin to provide the culture and ethos of giving back, as well as the tremendous support the firm provides to make all these efforts possible. So again, thank you, enjoy the gala. Thank you to NLADA. Hope all are well and stay that way and enjoy a beautiful summer.
My name is Maggie O'Donnell, and I'm a partner at Zuckerman Spader and a co-chair of the firm's Pro Bono program. Our firm's commitment to pro bono is central to who we are as a firm. We devote significant time and resources to ensure that everyone has an opportunity for justice, particularly those with barriers to direct representation. 2020 was no exception. Last year, dozens of Zuckerman lawyers participated in these efforts. My colleague Avery Pollard, among notable others, made a significant impact for our pro bono clients.
On behalf of the firm, I would like to thank the National Legal Aid and Defender Association for recognizing law firms that are focused on addressing systemic racial disparities. We are honored to be named among the prestigious law firms receiving the 2021 Beacon of Justice Award. Last year, we sought to combat systemic racism on a number of fronts, including through helping clients navigate the criminal justice, housing, and immigration legal systems.
Zuckerman Spader looks forward to continuing to work on addressing racial inequality in our society.